Um, First of all, I'll just run through who is here today. We have Nick Richardson, who basically heads up our company commercial team. He'll be speaking about sort of terms and conditions and contracts, etc., and those bits and pieces, what you really need to know. And after that, we're going to hand it over to Dan Crate, and he works on our dispute resolution team. In dispute resolution, we deal with like personal disputes, boundaries, property, company disputes as well. It's a sort of area that can actually make your life pretty miserable if you let it run on and on. And a lot of people do let it on and on because they can never actually see a way out of the dispute they've got. So Dan deals with that all the time. He'll talk to you about. Yeah, exactly. Your job is to make them miserable. He will resolve the issues. He'll talk about how you can avoid them and what you should do if you are in a dispute in terms of actually getting it resolved as quickly as possible using his services. First of all, I'll do a very brief presentation on RHW. I know a few of you in the room do know who we are. We're based right next to Guildford Station, literally in Ranger House, which does seem to be in a cloak of invisibility. You have people who stand outside it, up and say, I can't see it, where is it? There's a huge, great red brick building there, just 30 seconds walk from the entrance of the station. We've been there, how many years have we been there now?
Probably about 15 years.
15 years or so? Well, we've been in Guildford for many, many years. The company goes back to about 1835 if you really want to sort of put the roots right back there. But in the sort of current form, it's from about 2009, is it, RHW form? Yeah, around about then. So, just taking this forward. Some of the things we do, company commercial, that's covering everything of business needs, terms and conditions, contracts, share agreements, buying or selling a business, all those sorts of bits and pieces. Employment law, this is an area that sort of ebbs and flows a bit depending on what the government's thinking on in terms of tribunals and how it's being funded. But we can help with the actual employer side in terms of settlement agreements, redundancy, handbooks. Handbooks is quite a big area where companies will come to us and say, can you have a look through what we've got here? Is this going to hold together? Do we need to add something else? Because obviously employment law is always changing, so you need to keep on top of it, otherwise you can find yourself in big trouble. Family law, whether we like it or not, once you get married, you have entered into a legal contract, which always surprises people. We actually turn up at wedding fairs, and everyone's delighted to see us at wedding fairs. They really come towards our store saying, please speak to us. And they say things like, what are you here for? And they say, well, you actually are on a contract. This is why you had to go to the courts to get out of being married if you want to go for divorce. But we also do with mediation, post-nups, pre-nups, and children's international matters, anything and everything with family law. It's a big, wide area. You see a lot of nonsense in the papers about like divorce reform or quickie divorces and stuff like that. A lot of it does not exist, and even if they do reform it, there's still always the issues of what happens with children, what happens with people become very, very funny about money when they're going for divorce, hiding it away, pretending they haven't got it, trying to sort of disguise their situation, all those sort of things. Disputes, as we've all touched on, business to business, business to consumer, property, probate. Again, probate is an increasing one because of the complexity of families now. You have step families, people getting married 2-3 times. As soon as wills come onto the horizon, people who before were quite normal and orderly behaved and calm start behaving in some very, very odd ways. Quite often wills are put together badly. People go for the cheapest possible way of drawing together wills, and when they're actually put under scrutiny, they fall apart. So people get into arguments, which can go on for a very long time. Property, we deal with both with commercial and residential. Residential at the moment is absolutely roaring away. It was reasonably quiet at the beginning of the year, which I think was partially down to Brexit. It's now gone completely berserk, so much so we've taken on extra member of staff to deal with it. I don't know what that indicates, but if anyone does know, then let us know. But this seems to be like gone from one end to the other. And private client, and that's to deal with wills, probate, trust and lifetime planning. Again, if you want to have a discussion, quite a lot of people think they've got, every time we get a call about a will, people ring up and say, oh, it's very simple, it's just straightforward, just myself and the wife, and we've got one house involved. When you start asking the questions in terms of what happens in this scenario, what do you want to happen here, what do you want to do with this, and suddenly, all these other bits and pieces come into the equation. So if you go in for a chat with whoever you decide to get a will with, and you don't come out feeling perplexed and a bit worried, they probably haven't asked you the right questions, because you really need to think about it for a couple of weeks and go back to them. That's it really. We're based in Guildford. I'm going to hand over now to Nick, who's going to speak about terms of business and contract formation as a snappy title. I think we're going to work on that one. So just hand you over the microphone. side there, and pens and leaflets.
Can we take?
Yeah, we can take that off.
And at the end of this session, we're also going to be doing one-to-one sessions when anyone wants them at all, with either Nick or Dan. 15, 20 minutes, want to sit down and chat about something, so just have a chat with us at the end of the presentation. Okay, hand over to Nick.
Thank you, Chris. Always difficult following Chris. I just want to say, Chris was talking about when wills go wrong, people start disputing. That we're talking about wills other than those prepared by RHW. I just wanted to make that point crystal clear. And if you'll forgive me, I haven't got my jacket on. I decided I couldn't compete with Stuart, so I wouldn't even try. Plus, it's really quite warm in here. I also said to Chris, can you just make sure that really snappy photo goes in rather than one that actually looks like me? So there we go. That's the load. Right, contract formation, really riveting. We were talking about how exciting accountants' lives can be. You've got no idea compared with how exciting a legal life can be. I'm actually going on holiday shortly, motorcycling trip, 2 lawyers and 2 accountants. Everyone, yeah, exactly. People say, you can imagine what the conversation over dinner is going to be like. Actually, it will be really, really exciting because we'll be talking about bikes. The topic here, contract formation, offer, acceptance, consideration. These concepts might be familiar to you. Everyone in the room is probably a bit of a wannabe lawyer. I'm a bit of a wannabe accountant as well, just as a little confession there. But a contract formation, very, very straightforward. There is nothing remotely complicated about what I'm talking about. It may appear a little bit complicated. It isn't. So always just go back to these basic concepts. To create a contract, there's got to be an offer. That offer's got to be accepted. And there's got to be a very, very strange concept called consideration. Now, any idea what consideration is in the room? Very straightforward. Money, absolutely. I think we can take it as read for the purpose of this discussion. Money will change hands, so we're not going to look at consideration again. But those are the 3 component parts. I always have to thank Chris for this particular graphic. It's make me an offer. The trick here, the trick in terms of avoiding a problem or spotting when a problem is going to happen is who's making the offer. Does anyone run a business where you send out quotes? Possibly you. Do you actually put anything in the quote, small print on the back, in terms of contract formation and when a contract might come about? Sensible. Listen on to what I've got to say, and you can then work out if what you've got covers it or might need to be tweaked. What you need to do if you send out a quote is make sure it's not legally an offer. If you send an offer out to a prospective customer comes back to you saying, thanks very much for that quote, I'd like to go ahead. Ka-ching, that's the contract formed. Money is going to change hands later on. Don't worry about that. That's the contract formed. If you haven't done your credit checks at that point and you then find, perhaps this person is not someone I want to do business with, you run a real risk that it's already too late. So you need to engineer it that whatever you do, whatever paperwork you send out is not considered to be an offer. So you get the customer or prospective customer to send stuff into you, which is the offer, and you then have control because you can decide whether or not you actually want to accept it. Because once the acceptance has gone in, there's the contract. So the trick here, take control of the process. Very, very straightforward, but a lot of people make a mistake. And the concept of making someone an offer, and you then can't refuse it. If you it's then too late. The Battle of the Forms. Anyone heard of this before? Well, I refer to it as a glorified game of Snap. Again, coming back, well, it's very, very simple. I've brought a few bits of paper, so I can use those as a prop. If you send out paperwork, you need to make sure your terms of business are incorporated in any contract. And the rules are, your terms of business have got to be brought to the attention of the other party to the contract, either at the time the contract is made or before, i.e. no later than that. So if you send something out, whether it's a quote or something else, the contract is then formed and you say, oh, by the way, here's our terms of business. Again, that's too late. The Battle of the Forms, if I just go over here and get my props, if you send your quote out and you've got your terms of business on the back, and I'm absolutely confident you have, you're putting the first card down, sorry to cover your phone, in the game of Snap. If they then come back to you and say, I'd love to do business with you, but I really don't think your terms are very nice. Here are our terms. We can do business. Let's form a contract on our terms. They've put another card on. You can see where the game of Snap analogy comes from. If you then say, that's fine, you form the contract, whose terms of business are going to prevail, yours or the other side's? The other side's, because they've put them down last. So if you don't like their terms, you don't want to form the contract, whether you're in control of it or not. So you then have to go back and say, fine, we're very happy to supply, but it's got to be on our terms. And that can go on and on and on for some time. So who blinks first is possibly going to lose this particular game. That's what the Battle of Forms is. I'll give you your phone back now. Thank you very much. So be aware of that particular trick. When is the contract being formed? Whose terms of business are actually... Sorry, Chris, I'm standing in front of you. Whose terms of business are on the top of the deck? And that's what's going to be the critical thing. So I put there, never, ever, ever. It's always good to repeat myself. Make an offer. Always have the other party to the contract make the offer. And correct use of an order form. That is very, very straightforward. Comes back to order forms, quotes. Put legal wording in there to make it quite clear, irrespective of what it may look like, it's not an offer. Some people use terms of business to regulate what they do, supply of goods or services. Some people, normally bigger firms, have terms of business that they use to buy stuff in. That's not really what we're talking about. It's rather more your own terms of business, and those will apply when you go out to the world at large. That's what we're looking to cope with. I don't know if anyone's had any experience, good, bad or indifferent, dealing with really quite large organisations, and they might come out with what they refer to as a service level agreement. It's probably not a service level agreement, saying if you want to supply anything to us, whether goods, services or otherwise, here's our agreement, normally about 150 pages, you will do so on these terms. It's quite daunting. A lot of people come to us saying, well, we've had this rather bizarre document in, we don't want you to check it out, but we're a bit worried about paragraph 17.3. Could you just double check and sense check that for us and make sure it's all okay? Under those circumstances, the best rules, and we'll come on to that, the best tactics to apply with a big organisation, know your bargaining strength and know that you're never going to be able to outmuscle the likes of BP's legal department. Unless, of course, you're the American government, but that's another issue. So if you've got concerns about paragraph 17.3, rather than the intimidation factor of having to take on a 150-page agreement, deal sensibly with them, and they will deal sensibly with you, in my experience. There's no guarantee involved in that, of course, but if you go to them and say, actually, your 150-page agreement is a bit over the top for this, here are our terms of business, you won't ever win that way, dealing with that. They'll just say, it's the classic computer says no concept. Here's the SLA, if you want to supply to us, please sign it. So pick your battles. If you've got a particular concern over a particular clause, deal with it, and they should deal sensibly with you. But again, keep it simple. Terms for payment, again, if your terms are going to apply, you might have negotiated with BP, for example, that all of the provisions in our 150-page agreement are going to apply, but the terms for payment are what you want rather than what they want. You may or may not win that particular battle, but terms for payment, be aware of what they are and be aware of what your business requirements are. Some have invoices payable on delivery. Some have invoices payable 28, 30 days after delivery. Most organisations, as I'm sure we're familiar, irrespective of what the contract terms are for payment, they will try it on and just see who blinks first in terms of how long can you hold out before you enforce your payment provisions. Tactics on that, we could have an entire weekend conference on that, but I won't. If you've got accountants involved and lawyers, it will be a wonderful weekend. Rest assured of that. Moving on, terms of business. If you've supplied something and someone hasn't paid you, you probably want to go in and get it back. Can be a bit of a problem area. Again, with apologies for the graphic. Is that Apocalypse Now, Chris? Yeah, yeah. I won't say anything about breach of copyright or anything like that. Yeah. So if you want to go in and recover, you've got to make sure your terms of business, assuming your terms of business apply, going back to the earlier one, actually regulate your ability to do it. Now, without giving away too much detail, you need to make sure that the other party to the contract is legally entitled to be in the premises they're in, and you need to make sure that your small print actually enables them to grant you a license to go in, because otherwise you're not allowed in and it's trespass and they can turn you away, and that legally the items in question remain your property, otherwise known as a retention of title clause. And I'm sure if you're supplying stuff, you've got retention of title clauses in there. Anxious looks around the room. Yeah. I'm looking at everyone. I have a squint. So yeah. It's anyone who supplies goods should have a retention of title clause, and a retention of title clause, very, very straightforward, like most legal things. If you supply something and they haven't paid for it, ownership in the items that you've supplied remains with you. It hasn't passed legally. I'll give you an entertaining legal trivia case in just a moment involving curries and people doing a runner from Indian restaurants in Leicester in the 70s, but I'll come on to that in a moment. Legal title has not passed, so you're entitled to go in and recover what remains your item. The well-worded clause makes sure that the gaps that might otherwise appear in that are plugged, so that you've got the necessary legal permission to actually go onto the premises to recover. And if you think about the sort of situations where people haven't paid, the customer hasn't paid, and you need to go in and recover, chances are you could be talking about a company administration, receivership, liquidation, that sort of thing. The first thing liquidators will do, and I'm sure our accounting colleague will back this up, is say, you've got no entitlement, please go away. So your first test is persuading the liquidator that you are in fact entitled to come in. And the first thing they'll do is have a look at the contract supply, and then they'll pull it apart. So if you want to have that protection, make sure it's properly drawn. I've got there personal liability of signatory. It's a bit of a legal tactic, dirty tricks department as well, if you like. But if you've supplied to someone and they haven't paid you, there are tactics that you can adopt to actually pursue the person who's signed on behalf of, say, a company, and claim that that person is personally liable. I'm not going to explore that in too much detail because I'll be giving away trade secrets, but there are tactics that can be employed, and if nothing else, a lot of the advantage of a good legal process is in terms of scaremongering and threats. So if you can scare the person involved, chances are all that will happen is that you free up the flow of cash, which is really what we're concerned about. This is, at this point, it's a credit control damage limitation exercise. Pitfalls to look out for. Make sure your terms apply in the first place. Prevention is better than cure. So coming back to that very first opening slide, formation of contract, your terms of business, if they're applied in time, at what point have you got to send them out to the other side? Can anyone, who was paying attention at that point? At the quote stage, before the contract is formed, absolutely. Does anyone put their terms of business on the back of an invoice? Anyone? Absolutely. Second bullet down, the invoice trap. After the contract is formed. It's going to be after, isn't it? Not always, but more often than not, it'll be after. Terms of business have got to be in place before the contract is formed. That's why it's called the invoice trap. Legally, there's absolutely no effect, no purpose in doing that unless you're going to supply on a rolling, ongoing basis, in which case you can say for the next supply, actually the terms of business were brought to your attention before you made the contract because they were on the back of our invoice. But that is legally, that's the only benefit in doing that. Yeah.
Do you have to send terms of business, or can you say, please consult our website for terms?
It depends on whether or not you're a railway company, because if you buy a train ticket, they always say terms of business are on the website, and they give you a web address. And I know many people who go up to the ticket office, get out their phone, say, hang on a minute, I'm just going to check the terms of supply. Obviously, we all do that. And yet, they will, whether you've checked them or not, whether it's reasonable or appropriate, whether someone's got a mobile phone, whether it's fair to impose that sort of condition, that is the only scenario that I'm aware of where those terms are found to be binding on you, whether you've actually not only checked, but had a sensible opportunity to check. In the real world, you've got no chance of checking there. If you say terms of business on the website, in my view, court cases generally go on in the direction of no, that's not bringing them sufficiently to the attention. It's a good place to put them anyway, but generally speaking, it's not enough. So paperwork-wise, send them out. PDF is fine. You can use email, but you need to have a paper trail by email, an evidence trail that has actually happened. Reference to the website.
So the challenge of the website is you can change that at any point.
You can change it on any point, yeah. So you can keep it bang up to date.
Yeah, but if someone's agreed to the terms of business 3 months ago,
Mm-hmm.
they've got no way of saying what that was 3 months ago because you've since changed your website and updated the terms of business. So I suppose having a record of it, printed or sent or agreed
Yep.
evidence.
Well, the terms of business should have a version number and a date on the back. So yeah, the virtual one, you're absolutely right, will be the version in force from time to time, but people will sign up to a particular version. And you can, by updates, bring people up to date with latest terms. Your credit card, for example, they'll just send you a revised set of terms and conditions. Whether you've agreed to that or not, do you think they're binding on you?
But if you then receive those and then use the credit card again, then in their eyes, you may have done.
Well, that's probably paragraph 1.1 of the new terms of business. Use of the credit card involves acceptance of these terms. It's potentially a grey area, but is someone going to argue with Barclaycard over their terms of business? Probably not. But again, let's not get into detail. Keep it simple. It is very, very simple. The rules are, get your terms of business to the attention of the other parties of the contract before the contract's made. The rule says no later than the time the contract is made. There's no point in risking it. Just make sure they're sent out before the contract is formed. It's not rocket science.
Interesting side note, Google actually likes to see privacy notice and terms and conditions on your website. So that actually forms part of what's called EAT, expertise, authority and trustworthiness. So if nothing else, having your terms of service and your privacy notice on your website will put you in good stead with Google.
Thank you, Stuart. Yeah, good practical tip. Completely non-legal point, but no, very, very fair real-world point. Retention of title clauses, I've already mentioned. You can incorporate these into your small print. Again, it's not a legal thing. It's rather more a practical thing. Terms of business really should be relatively short and sweet. A number of organisations use terms of business that run to about 30 pages. Again, the courts are going to say, is anyone sensibly going to read through those? It happens particularly in the insurance sector. Are these rules reasonable where you've got one particular paragraph perhaps hidden tactically right in the middle of a document like that, and it's in relatively small font? There are rules on how small the font should be, and generally speaking, once you start going below about 7 point, you're into a grey area, thin ice. So don't get too clever. Keep it, if it runs to several pages, it's better to do that at a reasonable level of font size than to shrink it down to 1 page and it's illegible without a magnifying glass. If it goes to a court, the court is going to say, has this organisation acted reasonably in the circumstances trying to deal with its customers? And when looking at a particular clause, is that clause reasonable in the circumstances? In a nutshell, yeah, that's what it is. Transparency, integrity, honesty. And I was going to just go on and say RHW, but I thought that's too much of a plug, but there we go, yeah. Well, absolutely, why not? Entering to recover stuff, I've already mentioned. Exemption and limitation of liability clauses. Always a wonderful topic. Again, we could organise a weekend conference, but I don't think there'd be much of a take-up for that. Just as an aide-memoire, an exemption clause says, I'm not liable under any circumstances for X or Y or Z. A limitation of liability clause says, I am liable, but I'm liable up to a certain limit. And there's a massive difference between the two. The other thing to bear in mind is you cannot contract out of liability for personal injury or death, whether you think you're entitled to or it's sensible to or whatever else. So if you ever go-kart racing, for example, it's always highly entertaining. They will always get you to sign a waiver. So if you injure yourself and it's their fault, you let them off liability. So all the lawyers always say, I will happily sign that because I know it's completely unenforceable. But that's basically what the rules are. And what is reasonable? I won't have any more invitations to weekend conferences, but it's going to depend. Anyone who's done any legal casework or whatever will come across this expression, the man on the Clapham omnibus. Anyone heard that before? The reasonable man test. Who is reasonable? Is this side of the room more reasonable than that side of the room? It depends on what day of the week it is, yeah. Is this group of people more or less reasonable than this group of people? Let's not open that one up. But yeah, the answer is it's going to depend. But the reasonable person is a typical person who's going to behave in a particular way at any given time. We all of us have odd moments where we think irrationally. I've had the odd moment where that happens as well. We're all human. But it's the typical person and how that typical person is going to behave at any one time. So coming to a summary, just wrapping it up, the battle of the forms, remember, just think of a game of Snap. Make sure your terms of business are on top of the pack when the contract is formed. Know the rules of the game. If you need to go on with a massive ping-pong exchange with this game of Snap, make sure your terms of business apply. It takes as long as it takes. And if it's getting a bit tedious, you can just make it clear to the other side, look, we're not going to deal with you on your terms. If you want to deal with us, it'll have to be on our terms. So what's it going to be? Are you going to deal with us? Yes or no? It's a bit about playing hardball, I agree, but it does save a lot of wasting of time. Play to win the percentage game. The point there is if you're negotiating with the likes of BP, don't think you're going to win, because you won't. But if you can negotiate on a particular provision that's of concern to you, they will deal sensibly with you, certainly in my experience. A lot of concerns people might have might relate to things like intellectual property. Who's going to carry on owning intellectual property rights at a particular point? The bigger the organisation, the bigger the fear factor. Intellectual property provisions, generally, you're unlikely to win any particular provision on that particular thing. Make sure your staff who deal with orders know the rules. Again, coming down to sending out a quote, sending out an order acceptance or whatever, at what point the contract is going to be formed, they need to be aware legally of what is going on and make sure that they're not making that mistake of making an offer that you then can't refuse because the other party has accepted it. And thank you to Chris for this delightful little summary. A little knowledge is bloody dangerous, absolutely. Make sure you have more than a little knowledge. I always say Google is a wonderful thing because it enables everyone to be an expert on everything. Well, it doesn't. It enables everyone to think they're an expert on everything, but in reality, it is nothing more than a little knowledge, which is absolutely. So that, in a nutshell, is that brief tour through contract formation. As I've said, it's very, very simple, but a lot of people overcomplicate it. It appears complicated, it isn't. You've got to know when the contract is formed and tricks to make sure your terms of business are going to be regulated by the contract and apply. rather than the other sides. And in a nutshell, that's it. Any questions, or shall I just pass over to Dan at this point?
Well, I think we'll have a few questions, and then we'll have an early-ish break, and then we'll come back to your colleague.
Okay, yeah, that's fine.
I'm dealing with two at the moment. The one well-being,
Mhm.
that what your background is with well-being contracts and parties, but we work with well-being practitioners,
Mhm.
holistic therapists, run events, ask them to deliver therapies and treatments to the public. Times now where somebody's pulled out at the last minute, so I know this will be a covering say cancellation. Back to whereas we would say, well, you've made a contract with us, you said that you need to pay for the venue and all those sorts of things. But she was talking about convention within an industry.
Yeah.
And I just wonder, within the context of the kind of expectations when the two parties put documents together and then put the snaps down, how much convention precedent expectation of an industry affects this?
It's highly relevant, and it all goes back to that point, what is reasonable? And the reasonableness test is one of the factors is what is traditional, what is customary within that particular market sector. So to that extent, it's very relevant. So if you're out on a limb and you're the only one operating this particular provision, and everyone else that they can quote and find says, no, there won't be a cancellation fee, it's going to be difficult to enforce it. But it might be in your terms of business, but they will say, actually, it's unreasonable. And you'll end up fighting it out in court. Which is a...
She was wrong, actually, because it's, in other cases, people do pay up. She was just trying to use that as a...
Trying it on. It's going to happen. Okay. It's going to happen, which is why you need to be able to fight back. And, which is why a very typical legal answer is exactly the one I've given, which is, it depends. So very rarely black or white, they're just grey.
I would just add, sorry, just to say that it's covered a bit in my slides that I highlight the need to try and have express contracts. They're written down. The contracts can, of course, just be formed without anything put down in writing. So if starting point, if things are in black and white, then it's really easy for parties to interpret what's been agreed and for the courts to interpret it. If there's just a contract done verbally, done hard law, offices and nothing's been written down, then the courts will look more at what's normal standard practice within that industry. So that's where they might look at the more of the industry and holistic therapy and how it's different to building contractors. But if you've got things in black and white, that's a really good starting point and something to fall back on.
Good. Yeah, Ben.
Question about quotes versus estimates. So we've tried to avoid using the word quotes
Mm.
because there's a lot of times where we're making a judgment on what we think the customer might need based on the information they've given us.
Yeah.
Or
Yes, you are, because it's implied into the word quote or quotation that it's effectively a fixed fee. So what you're saying is you're putting a label on it that it's a fixed fee, and yet you're putting small print later on to say, actually, it's variable under certain circumstances. But yeah, an estimate is nothing more than an estimate. And we've got exactly the same problem. If we give a quote, then we're expected to stick to it.
Well, on specifically that, is it good or bad form, like, if you're dealing with a client and giving 12 months price, to break it down into part quote, part estimate, so you can identify the parts you've got absolute control over,
Yeah.
and then you can detail the parts you don't have control over with an estimate. Is that acceptable?
I would suggest not only is it acceptable, it's actually very sensible. Because you can say, right, this part is fixed, that part isn't, because we haven't got control over it. I'll just spin it back, if I may, in terms of RHW. We do quite a few fixed fees, but we don't do fixed fees for what I call transactional work, where there's buying and selling involved. I'm not talking about conveyancing. I'm talking about buying and selling a business, simply because the variables are, if we're dealing with our client, we can be reasonably precise about what our fees are going to be for what we have to do, but our client is out of our hands. So our assumptions are that the client is always going to come back and provide sensible care. We don't quite put it that way, but you know what I mean, in a timely manner, whatever that may mean. If you're dealing with the other side, say we're selling a business, you're dealing with the buyer, and in particular the buyer's solicitor, we can only assume that the buyer's solicitor knows what he or she is doing. More often than not, they don't. They haven't got a blind clue. We end up doing their job. And you can see why, if we're doing a fixed fee, that really doesn't work out very well. So I think very sensible, fix what you've got control over, but stuff, yeah. But you need to watch wording which is ambiguous, because that will probably be construed against you. Yeah.
Actually, quote versus estimate, and where does fee proposal sit? Is this equals quote or fee proposal as a document?
A fee proposal is... no, a fee proposal is nothing more than that, but it should go on to say that this is an estimate based on either an estimate or a quotation, i.e. a fixed fee proposal.
The word estimate in correspondence and on the paperwork being sent to clients.
Yeah.
And then wait for them to say, I would like to go ahead, which is then not it's an offer to us, and then I say yes, as a word.
Well,
Is my offer then on?
yeah, absolutely. But the best way is to artificially create that by having your standard terms of business. So even if you forget to do it, it's in there anyway, which basically says whatever I'm sending out by way of a quote, fee proposal, estimate, whatever you use, is not an offer for the purpose of a contract that is capable of being accepted. It is, legally the expression is an invitation. So when they come into you saying, yeah, I want to do business with you, they're making you an offer, and you can say, yeah, fine, okay, get the contract sorted out, or actually we've checked you out, your credit worthiness is rubbish, we don't want to touch you with a barge pole, please go away. Yeah, yeah. And I'm not suggesting for a minute that you're going to have those issues. Yeah. Yeah. Sure.
Most of our products are supplied by companies that we buy from on a repeated basis. If we were to start with a new supplier whose terms were 30 days net from the date of invoice, but we wanted to change that to end of the month following invoice,
Yeah.
which is our standard date,
Yeah.
for most suppliers, do we need to do that on each order that we place with this company, bearing in mind that we might place 4 orders a month? Or do we need to establish that right at the outset before the first order?
What I would recommend, you can have, say, an exchange of emails varying that particular point and say this is intended to apply to any contract between our two organisations rolling forward in the future. And as long as there is an exchange agreeing that term as a variation, that should apply legally.
Just going back to your opening comment about place, if they say after the first order is placed, if a subsequent order is placed, and in their on their order form, their order form, it states the terms 30 days net. Does that supersede my email that I sent at the beginning?
If technically, yes, you do. If it's an appropriately clearly worded exchange of emails, this is intended to apply to any contract between us going forward into the future. It should apply. And you've got your evidence trail. The intention of the parties was that particular provision. And I'm assuming that you are effectively agreeing that all contracts going forward will incorporate their terms rather than yours, except as specifically varied. But that, yeah. Oh yeah, absolutely. The curry, forgive me. Yeah, I do. I've got a reputation in the firm of, God, he doesn't half go on. But I always get to the point in the end. But thank you. There is the Theft Act 1968, and there's the Theft Act 1978. And what the Theft Act 78 brought in was plugging the gaps in the Theft Act 68. So before the Theft Act 78 came in, if you went into a petrol station, filled up your car with fuel, you could then drive out because ownership of the fuel had passed to you because it's in your car. So you cannot steal what belongs to you. So a number of prosecutions failed because legally it was impossible to steal something that belonged to you. So it took them 10 years to scratch their head and think, something's going wrong. And similarly, if you go into a curry house, you eat the curry, ownership in the curry, it's inside you, is in yours, so you walk out and they can't do you for theft. So the Theft Act 78 brought in the offence of making off without payment. So even though it's yours, you've made off without payment, so you can still get done for stealing something which is already yours, because it's not the offence of theft, it's the offence of making off without payment. Yeah, and believe me, a lot of people did. Yeah.
So if I were just to sum up what you're saying is that it's good practice for us to include, if that we're in that context, of estimates in our correspondence and exchanges and in the formation of the snap game of to say this is my expected quote, to build in things like variables and terms and conditions. I have a pet client when I first it was so change in terms
Yeah.
of what I was going to offer. What I did do with that was do another home visit and just sort of renegotiate. But it would be good practice for me to put in my terms and conditions that should the number of animals change, the price will have to be revised.
I think it is. I cannot confirm that my advice and recommendation is do an estimate, not a fixed fee. I'm explaining some of the difficulties we've got as a law firm. If we give a quote, we have to stick with that quote, even though we might not have thought it through properly, and even though the goalposts change on us as regards what we're actually doing. You've got to look at it in terms of your business and whether everyone else does quotes. So if you say it's not a quote, it's an estimate, it's going to affect your credibility as a business. That's a decision that only you can take, not us. But I think it's sensible to safeguard your quoting process or estimating process in terms of the parameters that affect it and what might entitle you to vary the fee.
So the phrase I use I put the kind of variables in so that when I so that phrase should, in theory, sort of
It sounds like it's going to cover it.
that those kind of
Yeah.
different
Oh, it's behind you.
Last question, and then we'll wrap up and have a quick break. You will be available at the end for continuation and
Chris is nodding yes, so I guess my hands are tied. Yes, I'd be happy to stick around.
we've got a situation at the moment where, for a variety of reasons, we're varying our terms of hosting contract, and we're forcing people down one of three routes. Either they can do certain things that we need doing themselves, there's no additional cost, or there's an additional cost and we're offering them two different ways. What happens if somebody ignores the deadline we put on that? Would a contract then said to have been formed that because they hadn't notified us that they didn't want to do any three of those things, that we have said to them, we're going to do this one if you do nothing, if you don't tell us anything, and there's a cost involved? How does varying it in that way, is that legally fine?
If it can be, you're basically trying to negotiate a default position, i.e. if nothing happens, then X, Y and Z will legally be the case. So as yeah, it's just call it the default scenario. If you take no action, if we don't hear from you, if you don't say we don't want to do this, then you will be deemed to have accepted this provision. It really comes down to, is that reasonable in the circumstances? Probably is, but there's no cast iron assurance.
Yeah, we just want people to update their website so it's secure for the rest
Yeah.
of everyone on the server.
Yeah.
And they're not doing that.
Yeah, and I'll give you an example of where possibly it may not be reasonable. How much notice are you giving?
30 days.
30 days. What happens if that person is on a 4-week holiday? You can see why you can't get a categorical assurance that it would always be 100% reasonable. Because if someone came back and said, I've only just got your letter, but technically the deadline expired 2 days ago, it's pretty unreasonable to expect him or her to be bound by it.
Yeah, okay.
So again, very rarely is it black or white. It's normally grey in the middle.
Yeah, I don't think we'll have necessarily a problem. People will either decide not to stay with us or get us to do it. You know. But, anyway, thank you very much. Round of applause for Nick.
Yeah.
Take one of the bags there, the top woolly Hessian, if you can say that.
Well, we've got £50 note to say.
It's quite nice, actually. It's just a surprise in it. send a prize to. So
Like a free contract or something.
free contract. No.
What, are you
One of the next contract
intimating that
weekends.
Borden isn't glamorous?
Bordeaux, I said,
The
moving on.
Bedoin is.
Actually, you're talking about Bordeaux.
Bedoin.
Moving on, because when I used to live in Guildford, I used to live in Stoughton. You know, Stoughton was just about 20 years ago, so the Royal was there or whatever like that. And one of the residents there had a campaign to try and rename it St. Alton, which I thought was the best way to try and like up the mark. Didn't actually get anywhere, so I was right behind it. Anyway, moving on, I'm going to hand over to Dan now, who's going to talk about disputes, particularly in the business sphere, how to avoid them or how to deal with them if you have a dispute going on, and anything else that comes to mind. So, over to Dan.
Thanks, Chris.
Please.
Thank you, everyone. I feel a bit like a rock star with this mic on and everything. I didn't expect that to be here. Yeah, it's first time in the Bourdoin, so nice to be here. Thank you, everyone, for making me feel really welcome. It's a really chilled out, nice atmosphere. So, slightly different to Nick's presentation. I don't know where to stand if there's a camera. Stand here. Perfect. Okay. Had no stage direction. So, yeah, I'm Dan Crate from RHW. I specialise in disputes, so quite a wide range of bits and pieces that I cover day to day. So it's always interesting work that comes across my desk. Try and operate this thing. That's me. So the title involves a watermelon. Dan Crate disputes and a watermelon named Dave. Unfortunately, there is no watermelon due to supply issues at Tesco's this morning. So I've got a honeydew melon called Henry instead. There's no particular reason for the melon at all. I did a presentation in Halloween and I used a pumpkin, but I thought it would be a bit weird if I used a pumpkin this morning. So it just kind of represents maybe a business partner or friend or relative in disputes, just a random melon. There we go.
He's been working with himself for a very long time.
Yeah, it's the first time we've been let out in 2 years. People say when you do public speaking network, you never bring up politics at all, so I thought I'd ignore them. And so the 5th of June is today, but in 1975, that was the day of a referendum where the UK put to the public about the European Economic Community. And that's probably a big dispute that's ongoing at the moment, so politics aside and out of the way. First faux pas done. So I thought I'd just create a few slides where I was giving a few key points about disputes and how to avoid them. So hopefully, point number one is my advice would be to front load. So ideally, you never really want to be in a position where you will have a dispute in your business or personal life, but it's an inevitability of business life and personal life that disputes will arise. One way I think to mitigate that is to try and front load any sort of legal advice you get when you're starting up your businesses. So using Nick services or other solicitors' services that could be conveyancing with your private property or commercial property, getting your wills drawn up properly, and then at least then you've got a foundation of black and white documents that you can fall back on. So that would be my advice, and then it will hopefully save you money later on down the line if you've done things properly. It will mitigate the risks of disputes arising and help you nip them in the bud and hopefully reduce costs as well as a result. Now a plug for actually what I do rather than what Nick does. So another key tip would be that generally speaking legal advice is quite expensive. So yeah, obviously we add a lot of value to your business and day-to-day lives, but there's no hiding behind the fact that we're quite expensive, but we obviously do add value. Thanks, Chris. But I'd mentioned legal expense insurance. I can't give specific advice about legal expense insurance because it's a regulated activity, but I would advise all of you to check any home insurance policies or public liability insurance policies that you have with your businesses to see if it has legal expense insurance within the policy, because that will hopefully enable you to fall back on that should you come into a dispute in your in your commercial or private lives, and that will pay for legal fees. So if you haven't already got legal expense insurance, look at your policy, see if you can buy it as an add-on to your existing policies. So that's a good tip. All is not lost though. If you come into a dispute and you don't have this insurance policy in the background, you can just pay privately and we'll always happily accept your cash. We won't say no to that. There's also something called after the event insurance, which is a separate policy you can get to insure yourselves when you get into trouble. But as I'm sure you can appreciate, because the risk is then known to the insurer and what they're dealing with, the premiums are often a lot higher. So it's better to get it before the event, but there are after the event policies available as well. So another key tip, write stuff down. It sounds straightforward, but as Nick was saying, contracts can be formed when they are expressly written down in black and white. They can also be done verbally, just through a conversation down the pub between friends and family or business acquaintances. And with regards to consideration, it can be money, or it could again be just the exchange of melons. It doesn't have to be money. So if you get things down in black and white, that's a good key. And it can seem like probably quite restrictive in your day-to-day business lives to write stuff down, because at the end of the day, you just want to build your businesses and make as much money as possible and expand and make your customers happy. But I would recommend you just write things down. It doesn't have to be in letters or emails. It could just be through WhatsApp or on Facebook chats with your customers. As long as you've got an archive of something you can fall back on, it's something great. Likewise, even with Twitter, even though it's a social platform, if you've got something in black and white where you've had some sort of exchange, you can always fall back on that. So don't.
During actually, if you've got a dispute, is it also useful to have written record of any exchanges you have during the actual dispute itself, or is that going to be irrelevant?
Yeah, absolutely. So thanks for raising that, Chris. I should have paid you to. Yeah, so obviously when disputes arise, you'll often be probably speaking to the other party before you even think about approaching a solicitor. So do write things down and keep correspondence, ideally of emails or letters. It'll always be tempting to have phone calls, because that's quite pragmatic and it's the way the real world works. So don't be afraid to have phone calls, but just write notes down. Legal phrase would be write it down contemporaneously. Lots of syllables there.
What about recording phone conversations?
Yeah, I wouldn't recommend that. You would need the other party's consent. So you can record meetings and phone calls, but only with the other party's express consent. I think, so it's going into a slight area. So the question number one, with recording wouldn't be admissible in court unless the other party is given consent. If you're just simply recording it, then you wouldn't be able to use that again in court. The problem is over privacy and data, so recording it, even if you are just using it for your own purposes to type up a transcript, you're arguably breaching data protection rules, and it's a big no, a big GDPR as well. So general rule is get the other party's express consent.
If you were to
Or,
say, right, I'm recording this for my own protection, that's then not, and if they say no, I don't want you to record it, you have to stop recording, or?
yeah, it's interesting that this is coming up as a topic actually, because I have quite a few clients that, or people on the other side that aren't represented by solicitors, they'll often try and record me, or clients ask the same question. So it's a slight grey area because it's going into GDPR and data protection issues. But sorry, your question was?
So if I was on the phone with someone, said,
Yeah.
right, I'm going to record this conversation
Yeah.
for my own protection,
Yeah.
and if they say no, I don't want you to record it,
Yeah.
do you have to stop recording, or?
Yes, that would be my advice, because they've got to consent to it.
What about the
So-
companies where they say this call will be
Yeah.
recorded?
So yeah, so that's part of probably your ongoing. Behind all of that, when you call them up as a customer, there'll be probably terms and conditions which involve when you call them, and if you then go through to the following conversations, you're consenting to it. Absolutely, because it's often these big international corporations, isn't it, where they say they're recording, but Joe Blogs on the street doesn't have recording facilities at their fingertips. So
I think at that point you have the option to actually end the call.
yeah.
But obviously they've also called themselves back. They said only using it for training purposes, whatever. So you couldn't actually then use it for other purposes apart from that.
And
So,
yeah,
they're very specific about the purpose of what they're doing.
and I'll just say, sorry.
No, that's giving you permission to record. Is it? Yeah, well, you think about it, this call may be recorded. So they're saying to you, you may record this call.
That is another way of interpreting it.
That's
another
how
way
I
of interpreting it.
and therefore record all the calls.
Quite often they say we are recording, but yeah, you could argue the other way quite really.
This call may be
It's
recorded.
consent.
Thank you for letting me record it. See, it's all in the wording, isn't it? It's all in the wording.
So that if we were in a meeting and we were working for, whatever it is, we're in a meeting and we know it's being recorded and we know that there'll be transcription.
And you've all consented to it.
So the fact that we've attended the meeting isn't enough of a thing, because GDPR requires a very specific acknowledgement of that particular extraction of data, isn't it? That
You have to
I would,
opt in.
yeah, have to be an
Can't
express sign-in.
So perhaps in meetings between parties, in your terms and conditions, you'd say that we are recording meetings for the protection of both parties, and put that in as part of the understanding that if you attend a meeting, it will be a recorded meeting.
But you also, part of this, and I want
It's okay.
to get Dan to skip on, because this is about writing stuff down, not recording stuff, is
Interesting
that
topic
if
there.
you do record a call, you have to make it available to the other party
Yeah.
if they request it.
Yeah.
So you then have to make sure that you have an archiving method that allows you to extract the call and the information quickly, because otherwise you're going to just get bogged down in requests for, and there's cases running now where people are just bogging big businesses down with lots of little data requests. So make sure that if you are doing that, you have a process in place, because otherwise you just end up with a headache sometime down the line.
You've
Anyway,
got to
back
draw.
Dan.
Thank you, Stuart.
So
You've-
you could say, as you're saying, whenever you have a dialogue with somebody, you say afterwards, I'm going to write down what we've said so that we can then review whether we've understood each other correctly.
Yeah, there's nothing wrong at all by saying that you just follow it up. You can write down contemporaneous notes of what you've talked about. So in day-to-day, solicitors, when we have meetings or telephone calls, we write something called an attendance note, which is just like a memo of a telephone call or a meeting we've had. We would type that up, and then sometimes from time to time we can send it to clients so they can see what we've written down from the meeting, and if they've got any issues with it, they can raise that dispute at that time. But obviously people's recollections are different, so the key really from this point is to write things down contemporaneously. If you have a meeting at the 1st of January, don't suddenly write a meeting on the 3rd of May when you receive the dispute. Write it down, date it and sign it, or if you're typing it, obviously you've got metadata behind the document of when it was created.
And I've heard lots of people, and I've had it from personal experience with custody battles and things, to keep diaries when you've got ongoing disputes, just simply nothing complicated, just an ordinary diary, so it just records in one place, so you're not having to dig around later on. That as something's happening, just write down details in bullet points or whatever. So it's
Absolutely. It's always nice to have a nice little chronology to hand, because that's something a solicitor will ask for early on is, have you got a chronology of what's going on? And it helps them get to the key dates in the dispute. Thank you. What I would say on the flip side of this, of course, I think Stuart mentioned it, is that obviously if a party is recording you, and it's often these big organisations, I found it's helpful acting against these big companies from time to time, because they quite clearly say to my clients their calls have been recorded in correspondence or on the phone. So then from my point of view, I can then request the disclosure of those recordings and transcripts. Then all of a sudden, those documents aren't available, the recordings aren't available, and they very quickly settle. That's what I found in my experience with banks or utility companies, is because they say they've recorded it, and for whatever reason, maybe they've lost it, or they don't know where it's saved, or that they actually then listen back to the transcript or the recording, and they realise what we've been saying all along is actually true, so they settle. So it can be used to your advantage. So I've said write down there, but I guess that's quite old-fashioned, isn't it? Recordings and bits and pieces. So just things to be aware of. For friends and family, obviously we've all got friends and family, and I should imagine, well, I personally use my friends and family to help me get on with my career and lend money from time to time, or just help me with loans and things like that. And I should imagine when you're all starting up your businesses, you'll need to lean on friends and family from time to time to help you out, whether it's providing services or lending you money. And things might all be rosy and happy at the outset, but back to my watermelon, well, it's not a watermelon, the honeydew melon called Henry, a bit more of a mouthful. Henry might be really happy at the outset whilst he's your happy relative or friend, but quite often as soon as money's involved and things suddenly go a bit sour 6 months or 3 years or 5 years down the line, that relationship will fall apart. So by using a commercial solicitor or a will solicitor or a good conveyancing solicitor to get the black and white framework in place about any arrangements you have with friends and family, it's just helpful to fall back on. Likewise a bit with prenuptial agreements in marriage. I won't go into the pros and cons of it and how much weight they're given legally, but it's just useful to have a framework in place so you can fall back on it if a dispute does arise. But understandably, in the real world that we live in, people are always reluctant to do that, because when you're down the pub or whatever and you're setting up your business, it's the last thing you really want to do is spend money on that because you're in a good relationship. But it's something to bear in mind. And on that point, really just to flag up a bit of a horror story, I've recently acted for a client where he lent his brother-in-law over a period of about 2 years, about £90,000 for different businesses and business ventures. And for various reasons that the business he's gone bankrupt, or the relative's gone bankrupt, and various other reasons, he's not going to recover a penny of that money. And that's a big chunk out of his pension fund. So he's done something to help a relative and get out of difficult positions and help with the business, but just something to be cautious of. Absolutely, yeah. But it's too late now, so it's an expensive lesson to learn. But and that's after spending quite a lot of money on legal fees as well. So it's not just the original outlay; it's the legal fees that he spent. So if you were to get a formal loan agreement in place, it just helps. I'm sure Nick would be able to assist, and we've got teams that can assist with that sort of thing. It just helps spell out the position if things go wrong and how you get your money back quickly.
One of the biggest searches actually on this on Google, we see this all the time, we look at who's doing what, it comes up second or third ranking is how enforceable it is. It's not month in, month out, it comes out based on this is people who basically have lent money to friends, family, and have found it that the fingers burnt and thinking like, how can I get that back? And again, we could have another weekend conference on that, but basically put it in black and white. That don't, even if you know them, even though the other half, it's worth formalising these things because things can fall apart.
Thank you. There's not too many more to go, you'll be happy to hear. So director guarantees, this is really a bolt-on to the last one. Slightly, it's not really, I'll call it a separate slide. And it's something Nick touched upon. If you're going into a relationship with a company, company A and company B, or business A and business B, ordinarily it's between the two businesses or the two companies. And then if something goes wrong, you'd sue that company. However, if that company goes under for whatever reason, you're not going to. If you have something called a director guarantee that's signed at the same time within that agreement, the company can still pursue the director for their personal liability. So this is something you want to be aware of. If you're obviously going into contract with other parties, you don't really want that to be included. You don't want to agree to that your end because you want to be off the hook. You don't really want to allow people to come after you personally. But obviously if you're going into agreements with other companies, you want that other company to have a director guarantee underneath so you can pursue those directors personally. Does that make sense? Yeah, I mean, there's always an option. It's a contract at the end of the day, so you're not being forced to go into that agreement. It's just whether you want to go into that contract, whether you want to go into that agreement. So you can often ask the bank to take that director guarantee out, but generally speaking, I don't think any bank would necessarily allow that unless you've got a strong bargaining position your end for whatever reason. So just because one party's suggesting a director guarantee does not mean by any means that it has to stay in there. It's all a bit of a haggling process, and this is where Nick Services and commercial solicitors come in to negotiate that out.
I think you're fine with Lloyds or NatWest, then 99 times out of 100 is going to say you either do that or you don't get the loan.
And just tell you to jog on. But yeah, essentially. So this is a bit of a legal phrase, without prejudice savers to cost. So if you decide that if you come across a dispute and you want to try and settle it yourselves without using a lawyer, so doing myself out of a job here, because sometimes you'll find that your disputes are quite low value, so if they're just a few £100s or it doesn't really justify you using a solicitor, then make sure any correspondence you send them about making offers is strictly without prejudice, savers to costs. So that means, effectively, as long as you've got that in bold at the top of your letters, they can't. If they fail to accept it, you can then flag it up to a court at a later date and say, look, I've made all these offers here. Say the value of the claim is £10,000 and you've offered 1,000 or 5,000 along the couple of years, and it eventually goes to court and the judge only awards you or the other party £500. You can say, look, I've made these offers of 1,000, 5,000 2 years ago, and that gives you better leeway to then try and recover some of your legal costs.
And you have to add in, say that.
Yeah, that's right. So all that phrase means is that it's without prejudice, so it can't be brought to a judge's attention in any event. But then the savers to cost bit means that it's kind of like your trump card at the end of the day. Sorry to use that phrase. Or park political issues aside, one faux pas enough. And save us the cost means that you can just pluck it out at the end of the trial and say to the judge when the issue of cost arises is that, look, I've been more than reasonable over the last 6 months, 2 years, 3 years, 'cause that's how long disputes can take, sometimes longer, and say, look, I've spent 10 grand on legal fees. I made these offers years ago, had the other party accepted. This never would have happened, therefore, please get all the other guy to pay all my legal fees. It's at the court's discretion most of the time, but at least it sets you out well.
It's not an acknowledgement of liability. It's just
Absolutely.
simply you're saying we've just come to some sort of terms, or
Absolutely.
we're offering to come to terms.
Absolutely. So it's strictly without prejudice. So thank you. It's not any admission of liability whatsoever. It's just saying, look, I want to basically get on with my private life or business life. I'll buy off this risk of any sort of litigation or dispute by offering you X pounds now. And if you accept it, we'll move on. But it's strictly without prejudice. So you're not accepting liability, and it's not something that the other side can use at court until the issue of cost has arisen. Yeah.
I got an email with the without prejudice notice, and I was simply did a quick check. Find out that all it means it cannot be used in court in any case.
That's right. Yeah.
Is that still a valid thing? Because the email actually said we are refusing to pay your wages. That was the
Yeah.
the substance, the essence of the email. So can we actually, write anything in the email after close? And we can take away the mistake? Is that
Excuse me, too much coffee. Yes, the general starting point is that without prejudice means it can't be used whatsoever in any court proceedings or an employment tribunal or arbitration or mediation or anything like that. There are very limited circumstances where that is called a legal privilege on that document, where it could be, you could make a very technical application to a judge and say, look, they've tried to use without prejudice in this correspondence, but we think it should form part of the legal proceedings. But that's very, very limited. So 99.9% of the time, just proceed on the basis that if it has without prejudice in there at the top, it means it can't be used throughout the court proceedings.
So that means you cannot submit it as evidence.
That's
as
correct.
part of the dispute.
That's correct. You can do a separate witness statement, or
this is really technical now.
it's okay.
The simple reply to the without prejudice email, is that without prejudice as well?
Yep. So
And then
that's a really good question. So the,
Can I sort
yeah, of
give
course,
you a
Nick.
bit of time?
Nick's now going to tell me I'm wrong.
I'm come out with a slightly humorous anecdote at this point, because the best way, in my experience, to reply to a without prejudice letter is to send something back headed with prejudice. And it's amazing how the other side will just sort of die and wither. But I'm going to pass back to
Yeah.
That's actually not a particularly good bit of legal advice, but it's quite a
Subtle two fingers.
So I was thinking that I understand the without prejudice concept is allowing you to be able to negotiate without contract shackles But if someone is thrown without prejudice and given consent, obviously the dispute would then
and they can't then produce their correspondence against what you're saying.
Yeah.
So that you could potentially create a situation where they shoot themselves in the foot. You could be presenting stuff to the court that they can't do.
Yeah. So I'll just address that. So start with your point. If I write to you without prejudice correspondence, as I said before, take it as read that that can't be used in court proceedings except in extremely limited circumstances. Then, as you quite rightly said, if you then decide to write back to me and you don't write without prejudice on it, there's a big question mark over can that be used in court proceedings. The answer is, the starting point is no, if the other side are doing their job properly, because they'll say that you're replying to without prejudice correspondence, and therefore, by its very nature, it's the contents is without prejudice and shouldn't be flagged up to the court's attention. So if you were to try and include that within court documents that you send, the other side will be on red alert, and they will say that can't be admissible as evidence. Generally speaking, though, when parties have disputes, the correspondence about the dispute isn't generally used within the court proceedings. You'd rely on like formal court pleadings and witness statements. But you do want to jump on the idea that if it's not flagged up without prejudice and you're not responding to someone else's communication that's flagged up without prejudice, include it if it's helpful to your case. And then I think to address, yeah, it's very similar. So you'll just go around in a circle, but it's a useful thing to have up your sleeve.
But once they've initiated the without prejudice
Hmm.
train,
Hmm.
if they're tying your hands, because as your point
Yeah,
is that
yeah,
how do I
I-
reply back, it means that whether you agree or not with this
Yep.
salary dispute or whatever, you're unable to go down that
Yep.
pathway because they've deliberately taken
Okay.
it off, haven't they?
Yep,
As
so
a-
you-
as a tactic,
Yeah, so there's
the gag.
that's a really good logical point. So it's very easy to respond, or at least put forward your points of dispute. All you need to do is when you next write to the other side, as long as you don't make reference to that correspondence dated 1st of July, you can just say, this is my position, we want to get it settled on these terms. And because you're not referring to the date of the letter of that, you're quite... No, so and if you receive a without prejudice correspondence from me dated the 1st of March, and then you reply in a letter saying, "Dear Dan, thanks for your letter dated the 1st of March. I disagree. Here's my counteroffer, or here's my case." Then the letter you've sent me back will be privileged and won't be able to brought up to the court's attention. However, if you receive the letter from me on the 1st of March that says, "Without prejudice, I'll offer you £10 for you to go away in full and final settlement," and you disagree with that, but obviously you want to communicate to me that you disagree with that, all you need to say is, "Dear Dan, as you know, we've got an ongoing dispute. I completely believe that my case is strong because of A to Z. I'm willing to offer X if you want to put an offer in, or seek legal advice and escalate to court proceedings." And then that,
Stop end that
yeah,
discussion.
as long as you don't refer to it, yeah, absolutely,
And you let it die
Yeah,
with their approach,
yeah.
and you do it all over again.
Absolutely.
But this time you're the proponent, you're the one that's being the
Absolutely.
the driver
Yeah.
and starting the conversation.
Yeah.
going, and just let that just.
yeah, and you can refer to that without prejudice correspondence any time later on down the line, but quite often these things are structured in that any offers have time frames on them, but I won't go into that too much. Does that answer the question? Cool.
So ignore it, just simply ignore strictly without prejudice line and continue your own dialogue anyway.
Yeah, you can continue. It depends what you want. If you want it to be without prejudice, you can reply directly to that, and it continues to be without prejudice. But if you still want to advance your arguments, just continue to write, but just don't refer to the date of that correspondence. That's fine. Compromise, it's a bit self-explanatory, really. But quite often, well, I'd say I've been dealing with disputes in various types of disputes now in litigation for about 5 or 6 years, and it goes without saying, with all of the disputes I've dealt with, there will always have to be a compromise on my client's side. You'll never, very, very rarely, I don't think I've ever had a client in that time that's been 100% successful in getting what they want. Even if you know you're going to be successful at court, you just settle because cost risk are escalating. There's no guarantee that you're going to be successful. So with any disputes and with anything in life, really, obviously it involves compromise. So go into any dispute with that in mind. Obviously you can have your day in court, but that's going to be very expensive.
My uncle's a solicitor. In fact, my uncle and my aunt ran their own practice.
Okay.
He said the phrase that he always liked to hear when somebody came and sat down in front of him about a dispute was, "It's the principle of the thing." He said because he knew that even though he would be saying settle, 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 they would just keep running at it. So
Absolutely.
Book a new car or a holiday.
Yeah, I mean it's very true. I've got a lot of clients where they'll say they're willing, say even if the value of the dispute's £5,000 or £10,000, they'd rather pay me that to dispute a principle so that they've won. But my advice to them would always be, that's not for me, would always be, look at the bigger picture. Spend that money to go on a cruise or a safari, or spend the time with your family. Don't invest all that money in legal fees. And also you've got to try and harbour a good ongoing relationship with your commercial partners. So it can put a lot of stress on family, friends, and marriages. If you've got a dispute that's going on for 3 years, you might think early doors that it's going to be resolved very early on. I'm dealing with one at the moment where parties are married and it's very complicated. It's been going on for a long time. But it doesn't just put strain on your company, it's going to put strain on your relationships with your husband and wife, boyfriends and girlfriends. So just think about how you want to spend your life, whether you want to have a dispute hanging over you for 3 years, or whether you actually want to compromise very early on, using a solicitor very early on, if you can't resolve it yourselves, as you want to, and try and get people around a table and get things bashed out quickly to front load those legal expenses, rather than spending 3 years of your business life and personal lives worrying about something hanging over you, and all the time costs are escalating. So generally speaking, in my line of work, if a case goes to trial, all the way to trial, it's going to be at least £40,000 plus VAT and other expenses. So you're generally looking at £50,000, £60,000 at least. So it's a really expensive exercise. And even if you've won, at the end of the day, it's probably been very draining on your business and very draining on your personal life as well. So.
An old law professor used to say, never litigate when you're angry, and never go food shopping when you're hungry. So I thought they were like 2 really good rules. Very good advice.
Yeah.
You never get past the deli counter.
Yeah, just to win on the principles and an expensive exercise. Obviously, if you can afford to, and you've got nothing much better to do, then by all means use me, but I think there's better things in life to get on with sometimes. Am I meant to be saying that? No. No.
I'm just taking off the sales panel.
Yeah. So yeah, just relax. We've got it covered. So that's it, really. Thank you.
Are there any questions for the RHW squad crew massive team before we wrap up? Is there anything, because they're going to be hanging around for a little while, so anything specific to your particular requirements, I'm sure they can answer. No?
Well, we were talking during the break, weren't we, about the implications of some of these decisions on the way you structure a business. So in your front-loading sort of bit, we were saying that if we were talking about estimates and quotes and the different changes and how we couldn't necessarily go in advance, to do something like build a business where you've got packages. So if you know that there's going to be a lot of use of a particular level of business services, that do tiered banding so you prevent the kind of expectation where you say you're going to pay £10 and you end up paying £100. So sort of, and also within the process of the system to build in dialogues. We talked before in the break that a lot of the time is that if you're doing your template of like even like a MailChimp sort of process of just dialogue, just you're updating letters to the phone, then you're again preventing expectations, any mismatches, you're keeping people up to speed where there might be a cost implication, so that at that stage they could make a decision whether or not to go ahead with the decision or not. So it sort of dampen down any issues, but actually to make it part of a business process. So it was your big thing is obviously it's about automating a process, isn't it, so much? And understanding that there are ways that you could actually prevent a dispute by changing the way you structure your business and dialogue with your customer.
If you're going to...
Absolutely.
Sorry, Stuart, I was just going to say correct, but enhanced by decent communication.
Yes.
That's the critical thing as well.
If you're going to scale a business, you're going to need a process which is replicable without your direct input. So if you're having to negotiate every single contract and every single clause, that's a bespoke, and thus your cost per hour will have to be high enough to make it worth your while to sit down and nitpick through every contract. But like with us, if you buy your hosting services from us, our terms and conditions are quite clearly available for you at the point of sale to read, review, and do what you need to do. You can't afterwards say, well, I didn't read them, didn't know this. We made them available before and during and after the sale and give you a cooling off period, because you have to do distance selling. But it's knowing that in advance, which means that we can scale, because we're not getting everybody phoning us up saying, oh, could you send us your terms and conditions before we buy the hosting and all the rest of it. So I think that what a lot of small businesses do is, without giving anything away, is rely on a handshake and goodwill, and that will get you going. But it's not sustainable in the longer term, because you will have somebody who will either see things differently accidentally, like the phrase, this call may be recorded. I interpret it one way from my own advantage, and somebody else might have a similar clause and say, oh, you'll do such and such by so and so. Yes. And then it doesn't happen, and then you've got an argument, and then it's the he said, we said, and then you end up with arms being waved. But
Lucky you.
yeah, people are rarely rationality is rarely enhanced when money's involved. So knowing what that is in black and white before you get going and talking to guys like this is a really good idea, so that you don't end up with lots of headaches down the line you're finding that you can't recover it, or to recover it will be a costly process.
And when you're doing loan and grant applications, to actually factor in professional fees of legal fees as well as quite as part of the loan request is useful as well.
Yeah.
A lot of startups don't include professional fees, whether it's accountancy or legal.
And dare I say, the bank arrangement fee for the loan
Yeah.
and the admin fee for paying it off early. Sorry, there's no bankers in the room.
No, but this is really important. It's like it's when you see bigger organisations and bigger business and the way they structure their business and they charge various things, and you think, oh well, that's unfair. Well, why aren't you doing that in your business? It is fair. If it wasn't fair, it wouldn't be legal to a certain degree. So if you feel that, hey, hang on a minute, I'm onboarding a customer and they want something extra or different, have the term in your terms and conditions that if you vary this, there will be an admin fee. That is entirely reasonable. And then you can say to the person, oh, you want to change to our standard terms and conditions, there's a £500 fee for arranging it. They might then suddenly decide, oh, actually, these will do. You know, we're quite happy to work within these arrangements. And that in and of itself shows a very business-like attitude, because it says, I am willing to work with you, but I'm not willing to bear the costs of your need to bespoke this particular service. So if somebody came to us and said, oh, your packages are great, but we need this package over there, happy to take your money, but this is the cost implication. So having that in place before you start prevents having a chat with this chap.
I think just on the point that Stuart was mentioning about costs, I'm sure you already will do it anyway, but a lot of disputes that I have with regards to costs or where there's sums involved, sometimes one of the sticking issues is about VAT. One party's forgotten to mention VAT, whether it's inclusive or exclusive, so always remember to spell that out, because obviously 20% is a lot of money at the end of the day. So spell it out, because otherwise you'll be stuck later on down the line, especially when you're making offers. Don't forget to include VAT. It sounds obvious, but
Cancellations you didn't cover, and
no.
cancellations tend to be a big thing for businesses.
Yeah.
And going back to what you both were saying about reasonableness as well, are there any areas that we can look at to say what is reasonable cancellation times again, or does that depend on business? I mean, I know everything in law depends kind of thing, but are there any guidelines about cancellations?
All I would say very quickly, because I think
We are over time.
Yeah. The difference between cancellation and termination. Termination is basically bringing a contract to an end earlier than the parties envisaged. Cancelling is basically saying something has gone wrong and I want to reverse out of it. So there's a massive difference between that, and different provisions are going to apply. I think we're in danger of going into another weekend conference at this point.
I think we've got 3 or 4 books.
Yeah.
Let's give it up for our guests. They've been very, very,
Thank you.
very